Procedure established by law. This phrase has been borrowed from Japanese constitution and not from USA. Now let us see the meaning of procedure established by law in between 1950 and 1978. That is to say, after the case of A.K. Gopalan versus State of Madras held in 1950 and before the case of Maneka Gandhi versus Union of India held in 1978. The meaning of this phrase was a person's life or personal liberty can be taken away only according to a procedure prescribed by a valid law enacted by the legislature. Thus, the actual meaning of this phrase was to focus on existence of law and not to focus on whether the law was fair and reasonable. And what was the result of this meaning? Let's see with the help of two examples. Suppose a student was expelled by the principal according to the school rules. Then the student challenged the expulsion in court. The court examined only two things. Number one, whether there was a valid rule authorizing expulsion. And number two, whether the principal followed the procedure under that rule. If both answers were yes, the court upheld the expulsion, stating that it would not inquire into whether the rule itself was harsh and unfair. You got my point? This was the meaning of procedure established by law. Now let's see another example. Suppose a man was arrested by the police and the man challenged the arrest before the court. The court, under the interpretation of Article 21, examined only two things: whether there was a valid law authorizing the arrest, such as the CRPC, IPC, NDPS, etc. And number two, whether the police followed the procedure prescribed under that law. If both answers were in the affirmative, the court upheld the arrest, observing that it would not examine whether the arrest or the law itself was harsh, unfair, or unreasonable. Now, I believe you have understood the meaning of the phrase procedure established by law, as it was interpreted before 1978. But if you want to know its present and expanded meaning after the Maneka Gandhi judgment, then stay with me till the end of this video. And if you are not a serious UPSC or judiciary aspirant, you may skip this video. Now, next point is that where this phrase appears in our constitution. The answer is it appears under Article 21 of our constitution. What does this article say? This article says, no person shall be deprived of life or personal liberty except according to procedure established by law. Then early interpretation. I have already explained the early interpretation of this phrase with the help of two stories, with the help of two examples. And now let us understand the present position by extending those same examples. Today, if there is a case of a student's expulsion, the court will not merely check whether a rule exists and whether it was followed, but it will also examine whether the procedure adopted was just, fair, and reasonable. In the same way, let's understand the present interpretation in the case of arrest. So today, the present interpretation is that if a man is arrested by the police and he challenges it before the court will not stop at merely examining whether there is a valid law like the CRPC, IPC, or NDPS Act, and whether the prescribed procedure was followed, but the court will also go a step further and check whether the procedure adopted was just, fair, and reasonable. And in case of the arrest or the procedure appears arbitrary, oppressive, or unfair, it would amount to a violation of Article 21 even if it is supported by law. Now I would like to conclude, but don't go anywhere, because in the very next video I will cover the most important previous year UPSC, PCS and judiciary questions based on this topic, exactly the kind of questions that are repeatedly asked in exams. So make sure you watch that video, because it can be a real game changer for your preparations.